What's up, guys? It's Michael Key, host of Real Conservative Talk. I want to say before I start this video, go subscribe to the YouTube channel, Real Conservative Talk. I'm going to put the link in the description for this video. But Facebook's been hammering me on some of the content that I put out, so I'm trying to drive some of that traffic over there. Now, the reason I keep kind of harping on the Rittenhouse case is because there's a lot of importance to it, along the lines of our right to self-defense and our Second Amendment rights. On top of that, a kid that was truly defending himself was found innocent of murder, thank God. And there was a lot that went into this that should never have happened. The whole trial being one of them. But I made a video yesterday kind of showing a scenario that Gage Grosskreutz, the guy that got shot in the arm by Kyle, actually lied about. And I'm going to break that down a little bit more today, but I'm also going to break down the closing argument from one of the prosecutors. And I think that a lot of what he said in his closing argument was not only laughable, but it's really kind of what ruined the case, other than the multiple screw-ups that they had before this closing argument. But a lot of what he said in this closing argument, I think, really ruined it for him. So we're going to break that down, and we're going to start with this video here.
That Mr. Grosskreutz could have assumed that he was re-racking and preparing to fire. And it does not mean that a unspent shell casing has to be on the ground. Officer Bray testified that she shot AR-15s. She knows AR-15s. If it jams and there's an unspent shell casing, the re-racking will take out the unspent shell casing.
Sorry, I didn't mean to pause.
It does not have to be a live round.
But I do want to pause that statement and go back here. Listen to what he says. And for anyone that knows guns is going to know that this is a crazy, stupid statement that he just made.
There's an And
to give us some context, what he's talking about is the scenario I discussed yesterday in the video where Gage Grosskreutz said Kyle was charging around. So he was re-racking the gun, whether it be to a gun jam or whatever. He said he was re-racking the gun. And the attorney is saying that he's talking about the bullets that were found on the ground. So actually, I'll let that play out. But listen to what he says about the rounds that were found. And these are all Kyle's rounds that were found from the AR-15. But listen real closely to what he says.
If it jams and there's an unspent shell casing, the re-racking will take out the unspent shell casing. It does not have to be a live round.
Now, he just said if it jams and takes out an unspent shell casing, that it can be an unspent shell casing. It doesn't have to be a live round. This is the round that Kyle was shooting. It's a .223 or 5.56. This round is unspent. Unspent means it hasn't been fired. If it's spent, that means it's been fired. This is what a spent round looks like. There's a difference. This is what comes out of the gun after he shoots it. Right here. They found 8 of these. Kyle only shot 8 times. They didn't find any of these. And I'm going to go into more detail as far as the gun jamming and stuff, but he said an unspent round can be discharged, but it doesn't have to be a live round. If it's unspent, it's a live round. So they would have found a round that looks like this if he had to re-rack the weapon. Now, here's the officer testifying as to what rounds she picked up. She's the investigator at the crime scene.
Yes, I'm familiar with all of them.
Okay, and what are they?
They are shell casings.
And are they all the same caliber?
Yes, sir.
And are they all the same make or brand?
Yes, they are.
And those were found in the middle of Sheridan Road?
Correct.
And did you find or log into evidence any unfired bullets at that location of that caliber and that brand.
No.
If there had been an unfired bullet matching those empty shell casings, is that something you would have taken as evidence?
Yes.
Thank you. Move those exhibits. Showing you what's been marked.
So she basically just confirmed what I just said, that there was no unfired rounds found at the crime scene. Just to recap, re-racking the weapon, this is an AR-15, means that he would have done this motion right here. That, or he would have had to have used his left hand and done it like that. Now, I already went over the video, and you'll see it in a second. Kyle never takes his hand off of the trigger grip or from inside or from in front of the magazine. He always has two hands on the gun, so he never charges the weapon. The only reason Kyle would have needed to charge an AR-15, when I say charge, maybe that's not the right terminology, but re-rack an AR-15 is if he was clearing a jam, or he had put a magazine in when the bolt was closed, and he had to pull the thing back to load the gun, which he didn't. If the gun was jammed, then they would have found a live round on the ground. In any jamming scenario that I know of, especially in the matter of time that it took Kyle to figure out that there was a jam and then shoot Groschwitz, they would have found a live round on the ground, which they didn't. So the gun was not jammed. He actually never even racked the gun. That's important because Groschwitz said that he was racking the gun, meaning that he had tried to shoot him already, at least from his perspective. Gage Groschwitz said that Kyle had already tried to shoot him, and his intent was to kill him. Therefore, he went from having his hands up surrendering to trying to maneuver around the backside of Kyle and do whatever he had to do to either unarm Kyle or eliminate the threat. Gage Groschwitz lied, though. Kyle never had a jammed gun. He never racked a weapon. And they never found a live round confirming that either of those happened. So this next clip, though, is talking about Gage Groschwitz's gun, which is a Glock 27.
As Defense Exhibit 147. Could you tell me what that is?
It is the magazine that was collected near the gun.
Okay, is that magazine loaded?
It is,
Did you ever determine how many bullets were in that magazine?
I believe, 9.
Is that on the label?
The amount of bullets?
Yeah.
No.
And lastly, Defense Exhibit 148. Could you tell me what that is?
This is going to be the unfired .40 caliber round I found near the gun.
Okay, so there was an unfired round D148 found in the same area as the shells that were in the magazine and the Glock, correct?
Correct.
And did you ever look to see if they were the same make and model?
I did.
Were they?
Yes.
So, might sound like an obvious question or a stupid question, but at a crime scene, if you find an unfired bullet, you pick that up.
Yes.
I have nothing further.
So for Gage Groschwitz's gun, in evidence they had the gun, which was a Glock 27 .40 caliber pistol. They have the magazine, and they had one live round. It would look like this because he was using a hollow point. This is a 45, but it's similar. They had one live round. Now, for there to be a live round outside the magazine, either someone took the time to take that round out of the magazine after he took it out of the pistol, or the gun was loaded, he took the magazine out, and racked the weapon to get the bullet out of the chamber. Now, he never fired it. A Glock 27 holds 10 rounds. She said there was 9 in the magazine. They found 1 outside of the magazine on the ground. They picked it up. That confirms that Gage Groschwitz had a loaded firearm that he was pointing at Kyle. Number one rule, or not number one rules, but one of the top rules. First of all, don't point a gun at someone you're not willing to shoot. And if it's loaded, you have the intent of using it. If you carry a firearm on you, when you go hunting, you're intending to use that firearm. If you're carrying a firearm as concealed carry, you may not be intending to use the firearm, but you have made that decision that you will use it if you need to. So your intent is, if I need to use the gun, I'm going to use it. You don't bring a gun for the mere fact of just to fucking have it. You don't do that. So when Groschwitz says, oh, I wouldn't have shot him, that's not me. If you bring a gun and you have a round in the chamber, you can't use that excuse. Now, that's not saying that you can't defend yourself. That's just saying that you are willing to use that gun if the circumstances allow it. Or not allow it, but have a need for it. That could be to defend yourself or to, if you're going to shoot someone for whatever reason, you're willing to use that gun.
I don't know what he was doing with his gun, but it's certainly reasonable for Mr. Grosskreutz to interpret it that way. And then what does he do? He doesn't step back and take a firing position and shoot. He didn't shoot him 5 to 6 seconds earlier when Mr. Rittenhouse was being an active shooter.
So he's talking about Gage Groschwitz, and he just said that Gage Groschwitz actually could have shot Kyle before that, 5-6 seconds before that, which Kyle would have still probably been standing, and he would have been justified because Kyle was an active shooter. First of all, Kyle was not an active shooter. In fact, there's video of Groschwitz after Kyle shot Rosenbaum going up to Kyle and asking him, hey, did you just shoot that guy? Like, what'd you just do? Blah, blah, blah. They talked to each other, had an exchange, not a violent one or anything. Kyle was just walking, never pointing the gun at him or anything like that. Groschwitz then turns away. It wasn't until after that did Groschwitz turn around and then go and engage Kyle. So if Kyle was an active shooter, Groschwitz never would have went up to Kyle in the first place. At any time. Kyle was never an active shooter. Ever. But he also said that, Gage didn't take his gun and point it out at him, right? He didn't step back and then aim it at him like he was going to shoot him.
After having killed his second person and shot at his third, he would have every right to have stopped Mr. Rittenhouse's activities at that point. But he didn't. He came up closer, he surrendered, and he said, he believed his surrender was not being accepted. Who shoots someone like this?
This is the biggest problem I had. Almost the biggest problem I had with the whole trial, on top of the other prosecutor pointing a gun at the jury. But if you truly believe that this gun, it's unloaded, I've checked it, and no one's in the house, so I'm pointing at the camera. If you think that this gun is any less lethal when it's right here, and it's loaded, as opposed to when it's out here and it's loaded, you're fucking crazy. You're crazy. This gun is just as lethal here. If it's pointed at something, it's lethal to whatever it's pointed at. If it was pointed at Kyle right here, it's lethal to Kyle. That's a threat. Even if he has his hands out in front of him like that, that gun is still lethal to Kyle. If I have my hand out in front of the pistol like this, and I'm pointing the pistol, if someone was in front of me, I'm still pointing that gun at someone. It is still lethal. That hand isn't going to block that bullet. So that's the stupidest thing that this guy ever could have really said. On top of this next statement that he makes when he's talking again.
Is he trying to shoot his own hand off? He never does anything about an actual position to shoot that gun. And as Mr. Richards admitted in his closing, when it's pointed at his head, his arm is already blown off.
So here it is right here. Now, he said Kyle was racking the weapon and that he was surrendering with his hands up. And that he saw, when he was surrendering, he saw Kyle racking the weapon. So he's like, oh, he already tried to shoot me. I need to move around and engage him. Now, I went over this yesterday. He didn't have his hands up at any time. The only time he put his hands up was when he flinched because Kyle shot the first Anthony Hubert, and Groschwitz was right behind him, and he got scared of the shot. He flinches, right? That's why he had his hands up. He still had the gun, and then all of a sudden he takes off. You'll see it here. Here's the second shot. Here's Groschwitz. See how he flinches? Now, Kyle doesn't rack the weapon at all. Here's the slow motion. Watch Kyle's hands on the gun. Both hands are on the gun. Let me make it bigger. Both hands on the gun. Both hands on the gun the whole time. Both hands still on the gun. Same place. Both hands still on the gun. Now let's watch Groschwitz. He's right here. See him flinch? That shot. Watch it back. He flinches. Kyle doesn't rack the weapon. All he did was kind of move his arm a little bit, the left arm, to get that sling. I think is what happened is the sling was in the way. But he never brings that left hand back to re-rack that gun. He shoots. Groschwitz never tried to surrender. He just tried to engage Kyle. He knew that gun was loaded.
We're supposed to be so scared of Mr. Grosskreutz with his Glock when the defendant is holding a loaded AR-15.
And that's the next dumbest statement that this guy made that ruined it for me with him. He was trying to convince the jury that this round is less lethal than this round. They're just as lethal. This one will kill you dead. This one will kill you dead. This is a hollow point. This is like similar to what Groschwitz had in his thing. This is actually will kill you faster, probably, than this one, depending on where you get hit. But a bullet is a bullet. They will all kill you. Both of the guns were semi-automatic. Means you could shoot them just as fast as each one. Groschwitz having a Glock was just as deadly, if not deadlier, because he would not have been as accurate and posed more of a risk to everyone around him than Kyle did with the AR-15. Honestly, you can make that argument. But for anyone to say that, oh, he only has a Glock 27 and Kyle had an AR-15 and we need to worry about the Glock, we don't need to worry about the Glock 27. We only need to worry about the AR-15. That's a stupid statement, and that's why you had idiots like these two pointing guns at the jury because they just don't understand weapons and firearms and safety with firearms and how they work and the lethality of them. They had no argument. That was one of the craziest things he could have said.
Holding a loaded AR-15. And now, a skateboard is a deadly weapon. Someone should tell all the parents and grandparents and Santa Claus giving skateboards this Christmas about how they're giving their children a deadly weapon.
A deadly weapon. It can be. If you go to hit
I guess
someone
they should
with
get
a
him an
skateboard,
AR-15
it's a deadly
instead.
weapon.
It's just
Same thing with a baseball bat.
preposterous. And yes, Mr. Huber was acting heroic in holding down that and taking that skateboard and trying to hold him down and trying to take that gun. And what happened? The gun stayed attached to Mr. Rittenhouse. Because when the defense concocted this, they were trying to take my gun story, they left out that it is literally strapped to him.
Now, I left it in there because I actually wanted to say something. And they didn't make this argument, but I don't think that Kyle Rittenhouse actually meant to shoot Anthony Huber. I think it was 100% an accident. If you watch, Like he said, the gun is strapped to Kyle. It's not. He said, it'd be hard to take in and take that gun away. But it's strapped to him, and Kyle is holding that gun like this. Except Kyle has his finger on the trigger. Anthony Huber jerks that gun away, and the shot happens right now. Kyle's arms are extended. He almost took that gun out of his hands, but his arms are extended.
To him.
This trigger, it's loaded. All that takes this trigger to go off is me pushing back on it or some kind of tension. If someone takes it, my hands are extended and they pull, and I'm squeezing that gun tight, I'm going to pull the trigger. Just the sheer force of that jerk from the gun. Hear it? I think that's what happened. I don't think Kyle actually meant to shoot Anthony Huber. That's what caused the gun to go up. Watch it.
My gun story, they left out that it is literally strapped to him.
Bam. Right when he extends it. Kyle did not mean to shoot him. That was 100% accident. He still had his finger on the trigger from shooting the last 2 rounds, and when Huber went up there to grab that gun and pulled it, because Kyle, I don't think he even saw him really until he jerked the gun. It was when he pulled that gun and his arms got extended is when that gun went off. I'll play it one more time. Bam. See that? That's what caused that gun to go off.
He shot an unarmed man 4 times because he was so scared that Mr. Rosenbaum was going to take the gun away from him when it was attached to him.
Now he's talking about the first guy, shot Rosenbaum.
It is an absolute ridiculous argument. Imminent threat. Not, in 5 minutes after we get beat up, then I might be a threat. Imminent threat. You've heard all the videos. I'm not going to go into it in any more great length, but...
Now, he said imminent threat, and I can't remember if I put it in here or not, but an imminent threat is literally something that's about to happen. Like synonyms with imminent are impending or about to. Like is going to happen soon. Which means that if Groschwitz has a gun pointed at him, that's an imminent threat. If someone is in the process of chasing you that made threats to you before that, which Rosenbaum did, that is an imminent threat.
When you listen to the crowd as Mr. Rittenhouse is running, they start yelling after as he's running when they're screaming, "Get him." Also, as people are approaching him at the end, they're asking, "Why did you shoot him? Why did you shoot him?"
Now that's right after the first shooting. People were going up to Kyle, talking to Kyle. If he was an active shooter, they wouldn't have been going up to him because Kyle would have been shooting all of them. People felt so calm around him to go up to him and start asking questions to him after he shot someone, but they wanted to claim that Kyle was an active shooter. And that's not true. They contradicted their entire argument right there.
These are people that were provoked because they witnessed an attack or heard shots or heard he was attacking, and they took action. As Mr. Bringer said, I probably wouldn't do it either. But that they did it is brave, and they did not deserve to be killed.
There's a difference between brave and stupid in that scenario. They weren't brave, they were being stupid. They didn't have to approach him. Especially because he was calm. They were literally talking to him right after he shot Rosenbaum. from the time that the second shooting happened. People were going up to him and talking to him. Groschwitz was one of them. Groschwitz literally went up to him and talked to him in between the first shooting and the time that Groschwitz got shot. He was never an active shooter.
Mr. Richards mentioned this in opening, but apparently he's noticed that the evidence doesn't bear it out. He talks about this, how Mr. Rosenbaum put this shirt over his head to hide his identity because he's going to go ambush Kyle Rittenhouse. Well, then obviously you watch the videos. He's had that shirt on his head for some time. Whether it's COVID, this is all pre-vaccine as we know. Whether it's tear gas, whether it's fire, whatever it is, he's using it to protect his face, not as some evil plan.
Now, I left that in there because in my video yesterday, I played a clip where Rosenbaum was in a crowd of people and he didn't have his shirt on his head. He was wearing a shirt, so he obviously didn't care about COVID. He also didn't care about the fires and stuff. That's not why he was wearing the shirt on his head. He was wearing the shirt on his head only when he started doing bad things because he didn't want to be identified. Because before that, when he's on camera saying the N-word, and that's in my last video of him doing that, he didn't have the shirt around his head. He did not care about COVID.
To get Kyle Rittenhouse. They're setting this fire, and they begin walking down Sheridan. There's no evidence that they knew he was coming. There's no evidence that they had any plan to get him. I'd submit to you that the Zeminskis and Mr. Rosenbaum were doing what they were doing all night. They were going to go bash that Duramax or start or stoke a fire.
And they make that like it's like no big deal. Oh yeah, he's just going to go burn a building down. What? That's not a big deal? Not saying, worth getting shot over, but that's not why he got shot. But they just like completely disregard the fact that that's a felony in itself.
Kyle sees this and then he runs onto the scene. That's clear in the FBI video. He runs onto the scene. He puts down the fire extinguisher. He raises up his gun. Mr. Rosenbaum yells, "Gun, gun, gun." Why else would he yell that? It's very possible that while he was yelling friendly, 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 he's doing so while holding a loaded AR-15 at the Zeminskis.
Now, the Zeminskis had a gun. They were shooting, when you listen to the video, I'm not going to play it now, but they were shooting off rounds into the air. This is all on video. They were egging Rosenbaum on to go and hurt Kyle.
Mr. Rosenbaum was going to chase him out of there to end the danger. And Mr. Richards boasts that, something along the lines, "You won't do shit, motherfucker." Well, Mr. Rosenbaum was wrong. Oh, that's an attaboy right there. Way to kill someone unarmed because you won't engage them. He raises the gun. He provokes the attack. He has to retreat. He has to exhaust all remedies before he regains the right to even use self-defense, not even to use deadly force. That's a whole other separate question. He does regain the use right to self-defense if he exhausts all options. He does not. He could have ran a different way. He could have fought. He had all sorts of different ways.
So he said he had to exhaust all options. He was supposed to retreat. He was supposed to run away, which in Wisconsin, I don't believe you even have to. So here's the video of Kyle running away before he turned around and used deadly force. Here he is, running away. He's like, "Oh crap, I'm trapped." Turns around and shoots. You do not have to take a beating. If you wait to defend yourself after you are already taking a beating, it's too late. You have the right to protect yourself from any kind of harm. Here's the close-up of that footage, but this is just him where he shoots him. But he was running away and turns around and shoots. This is another video. Look. Second video after people had already talked to him. Kyle was retreating before the shooting. He was running away. He's not shooting anyone. He's running away. It's not until he falls down and and people attack him. That's when he starts shooting. Not until he's on the ground. And then he gets up and retreats again to the police. Rittenhouse was never an active shooter. Ever.
Because Attorney Richards, perhaps on accident, misstated it. He said that the standard is that it could cause death or great bodily harm to Mr. Rittenhouse, or that it is likely to cause death or great bodily harm to Mr. Rittenhouse. That is absolutely not what the standard is, and that is not what this trial is about.
He's wrong. That is what the standard is. If something's imminent, we can't predict the future. No one can predict the future. So if it's imminent and it's about to happen, you're not... It's just you feel threatened in that sense. Again, you don't have to wait to start taking a beating and for someone to be in the process of whooping your ass before you start to defend yourself. You don't. He's wrong. The defense attorney was right. It's like he didn't... Like, just go on Google and look up the definition of imminent, dude.
Standard is the defendant may intentionally use force which is intended or likely to cause death or great bodily harm, such as fire an AR-15, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself.
Which he did.
Not, if you repeatedly smash someone's face, it might lead to injury.
See,
not,
He said, even if you were smashing someone's face, it may lead to injury. That can't be enough cause to shoot someone. If someone's bashing your head in the ground, if you're not already unconscious or dead, I'm sorry, that gives you enough, cause to do what Kyle did. You do not have to take a serious beating and risk being, impacted for the rest of your life, potentially, or ending your life, just because this fat attorney wants to say otherwise. That's not how it works.
This could have happened. Imminent death or great bodily harm. There's an old phrase that I could kill you with my bare hands. And there is literally no evidence that Mr. Rosenbaum was capable of that.
You never know who you're messing with. I've seen plenty of little guys beat the hell out of bigger dudes. There's always a bigger and badder person on the planet than you are. So even saying that he should have taken a risk against someone that he had no idea who that person was, and turns out that he was a bad person. This is why you don't take the risk, because you don't know who that person is. Rosenbaum was a very bad person. Very aggressive person. Very dangerous person. Especially to a minor like Kyle. Kyle didn't know that, but you don't need to know that, because you don't know, and the unknown is enough to put you in enough fear that when someone is chasing you and attacking you and making threats, then you feel fear for your life. If the reason we have guns for self-defense is for exactly what Kyle did, not to wait and find out that someone is capable of whooping your ass and then you get to use it, because it could be too late.
Mr. Rittenhouse has size on him. We heard how he's a swimmer. We heard how he's a lifeguard. He's apparently in some kind of shape. First, using other methods. We think that the 12 of you think that it is reasonable to have used force, deadly force in that situation. Shoots once, takes out his hip. What does Mr. Rittenhouse have to do to avoid that? Well, maybe take one step back. And Mr. Rosenbaum is no threat.
All right. So he's talking about the first shot. He shot Mr. Rosenbaum 4 times. And I'm going to show you a clip here of this guy deer hunting that I found. And I'm doing this because first of all, I think this is why everyone should have to go deer hunting or hog hunting. Other than multiple other reasons. But just because you shoot someone one time in the hip does not mean that that threat is eliminated. This is why The law says to neutralize a threat, you do what you need to do. That's why cops always end up shooting more than once. This is a deer getting shot, so if you don't want to see it, turn it off. So it's just a disclosure. It's not bloody or anything, but I just want to show you that this deer got shot with a bullet that was probably more like this one as opposed to this one that Kyle used. This is a 30-06. This is what Kyle used. Big difference in the projectile. This deer gets shot in the shoulder, which it needs to walk on. That deer runs off. Now, that guy shot that deer one time because he wasn't in like a threat with that deer. But even he reloaded that gun in case he needed to shoot it again. Shooting someone one time does not eliminate the threat always. Especially when they're on jacked up on adrenaline. These are people talking that don't understand how things work. You know, if the state really wanted to put Rittenhouse away, I don't know how they didn't get more competent attorneys.
And Mr. Rittenhouse is responsible for every round of that gun. It did not have to happen as fast as Mr. Rittenhouse made it happen. He could have held back at one shot. He could have held back at two shots. The guy in the blue hoodie who came in to attempt to kick him didn't get 4 shots. Mr. Rosenbaum didn't kick him. Anything else. And Mr. Rosenbaum and Mr. Rittenhouse are alive. That's not really in any dispute. I want to leave you with this.
This is the scariest thing he said, though.
The meaning of reasonable doubt. I'm going to read portions of this instruction. Obviously, you'll have the whole instruction. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. That's what the defense is asking you to do, to guess what Mr. Rosenbaum was doing, to speculate what Mr. Rosenbaum was doing, to speculate and guess what Mr. Huber and this unidentified man were doing. We don't know because he killed 2 of them. All we can look at is the evidence and see him standing pretty much straight up, or exactly straight up, when he was shot in the hip and immobilized. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. The defense's whole case has been trying to stoke sympathy for Mr. Rittenhouse.
So the reason why I said that's the scariest thing is he's talking about reasonable doubt, except the way he's portraying it is that the defense was trying to show that there is beyond reasonable doubt that Kyle acted in self-defense. What this attorney is assuming is that Kyle is guilty until proven innocent, which is wrong. The defense does not have to prove beyond reasonable doubt that Kyle acted in self-defense. Kyle is on trial for murder. The state is charging him with murder. The state has to prove that Kyle is guilty of murder beyond reasonable doubt. Not the other way around. It's kind of like in a football game when you see him reviewing a touchdown and they don't have the camera angle. They always say the ruling on the field stands due to, they didn't have the camera angle. They couldn't tell. They couldn't prove that call was different than what they had already put on the field. Because for them to overturn a call on the football field, there needs to be beyond reasonable doubt that it was the opposite way. Always in the United States, you are innocent until proven guilty. Some countries, it's not like that. That's why we're so... It's a reason why living here is so great. Because you're truly innocent until proven guilty, and the state couldn't prove Kyle guilty. But this attorney thinks otherwise. He thinks that the defense needs to prove him beyond a reasonable doubt that he committed self-defense, and that's not true. The state needed to prove beyond a reasonable doubt that he committed murder.
Showing how everyone else was just a terrible person.
And he's also saying that the defense was just speculating on what the two people that Rittenhouse killed was doing. Well, at the same time, he's asking the jury to speculate that Kyle Rittenhouse was, trying to commit murder, which he wasn't. On the video evidence shows that he wasn't. So his whole statement has been entirely contradicting and filled with stupid comments. They were very unprepared. And a lot of that unpreparedness came with the fact that they had so much going against them anyway, evidence-wise, that they didn't have a shot. But they really went in there and embarrassed themselves. So I just wanted to kind of go through that statement with you. Again, go subscribe to the YouTube channel. And this will probably be the last video breaking it down that I put on this topic. But don't forget, go share it. If you like the video, hit like, and yeah, go subscribe. Thank you.